I will introduce them very briefly. And I'll say that, of course, we have bios for our presenters in our background materials. The second section discusses ethical issues in AI, so ethical AI. Philip Dawson is Element.AI's lead for public policy, and Carol Pyle-Wiesen, I hope I've pronounced that correctly, Carol, is partner and co-founder of INQ Data Law. And I believe Philip is going first, to be followed by Carol. And again, we'll have presentations and then time for questions at the end. Thank you.
Good afternoon, everyone. Oh, I'm actually already mic'd. So thank you, Richard. You may have noted Richard and I are from the same company. His wardrobe is a little cooler. So as Nye said, I'm going to be speaking about ethical AI, but specifically some regulatory initiatives and challenges that have emerged recently in the last couple of years on this quest to guide the responsible adoption of AI or produce ethical AI, whatever that means. And this means that I'm going to be talking about some more of the risks of harms that we might have seen in Richard's presentation and what we can do about that. And what has been done about that. So now I have the clicker. And here we go. So a couple of years ago, some of the first initiatives that became public were national strategies. In fact, Canada's Pan-Canadian AI strategy, developed by the Canadian Institute for Advanced Research, CFAR, was the first such national strategy for AI. Most of these strategies, and there are now more than 20, have focused in large part on encouraging investment in research and the development of talent. Some of them have made mention of the need to guide the responsible adoption of AI, to develop human-centered AI, but largely they have not been very concrete on ethical frameworks. We've also had declarations. I've put up two, but there are probably hundreds of them. One of the first important ones came from a conference, the Asilomar Conference from the Future of Life Institute, which produced the Asilomar AI Principles, which again focused on high-level principles to guide the research that would lead to beneficial use cases of AI, human-centric deployment of AI, respect for human rights, and a more recent iteration and perhaps more developed has been the Montreal Declaration for AI, which our co-founder Yoshua Benjo was very active in developing. Now, we've also had ethical frameworks. So these are the internal corporate policies that guide the responsible or ethical design and deployment of AI. Some of the major companies have come out with principles for guiding their design and deployment. IBM, Google, Microsoft. Recently, Google very publicly announced that it was had assembled an ethical board, and then shortly thereafter dismantled this board. And this is some of the effects of this decision and this development on the future of ethical boards are still developing. Industry standards initiatives are also prominent. Two principal organizations on the international stage, IEEE and ISO, the International Organization for Standardization, each have different initiatives promoting trustworthy AI, developing technical metrics for trustworthiness or ethical design and use. But while all very different, one of the things that these initiatives has in common is the fact that they're not legally binding. So when we talk about introducing accountability for AI or ethical AI, what is going to ensure proper oversight and compliance for the ethical deployment of AI? Well, there's recent examples come from the European Commission, which assembled a 52-member high-level expert group on AI and recently put out its own ethics guidelines for trustworthy AI. But one of the key differences here is that they were grounded in human rights. Okay, so the proper context for formulating ethical principles, as articulated by this expert group, is the international human rights framework, or in this case, it was actually the EU Charter of Fundamental Rights. Our CEO was very active in this group, despite us being a Canadian company. He was invited to participate, and it ended up being a co-rapporteur of one of the working groups which developed these guidelines. So just very quickly, without going into a lot of detail, the goal, the output of these guidelines are government-regulated requirements, both technical and non-technical, and industry standards, okay? Rooted in human rights. So these are the 5 human rights and freedoms, or principles of human rights and freedoms that guided the context for the development of core values and ethical principles. Those technical requirements I was mentioning, including technical robustness, privacy and data governance, which Richard just touched on at the end of his presentation, accountability, transparency, and then again, thresholds and best practices for industry. So there's been a recognition that self-regulation, especially in light of the legacy of privacy protection online, is just not good enough. Other international efforts are calling for binding regulations as well. The OECD has put out principles for AI, developed by an expert group on AI, which one of our design research leads was involved in. And while OECD principles themselves are not binding, the principles themselves do call for governments to develop binding regulations. The Council of Europe, similarly, is undertaking a feasibility study of developing a legal framework to cover some of the gaps in legislation, regulations that have eroded the ability of the human rights framework as it currently stands to continue to protect citizens' rights. And then Canada, France recently announced an initiative called the International Panel on AI, and I think we're expecting to get more information about the precise mandate of this panel this week. But from their high-level statement of their mandate as announced in December, they too will develop standards that are grounded in human rights. So there's a trend that we see coming where if we're going to develop a comprehensive global framework for AI, where should we look? And people are increasingly looking to the human rights framework as something that is, I wouldn't say universally agreed upon, but that is an appropriate benchmark for the harmonization of regulatory developments. And of course, what has happened in the absence of binding regulations? Now, don't need to go into all the different scandals that have emerged in the last 2 years, but everyone is very familiar with Cambridge Analytica, the scandal which came to light about a year ago, which highlighted privacy rights violations, but not only privacy rights violations. And this is actually one of the first major scandals that shed some light on some of the other risks that users face online, in particular on social media. So there's also the unethical use of personal information and human rights abuses. So when we're talking about social media platforms, we're thinking especially of the freedom of expression, the freedom of opinion, the freedom of association, anything that impacts our ability to communicate freely with others and to digest an appropriate variety of information without interference from a third party. And I think another realization that emerged from Cambridge Analytica is that we were all been aware of for a while of the prevalence of targeted ads. And this is one of the fundamental the use cases, fundamental applications of AI deployments online and the use of our data is to target us with advertisements. I think what this revealed is that targeted advertising is but one application of AI deployment in social media. And it is, for the moment, been largely directed at ads, but the sequence of nudges and prompts and suggestions can be directed at many other types of outcomes, not just commercial outcomes, but social outcomes, political outcomes. And this creates important concerns for democracy, for personal autonomy, for dignity, and the lack of transparency behind some of these processes interfering with our basic democratic rights, the right to vote, elections. This has emerged as I think a broader and much more disturbing phenomenon. And of course, when you think that at the helm of this power are a few large companies, and for some of them, even one person, it becomes even more problematic. So you see regulators in the US, competition regulators in the EU calling for the breakup of these companies. In fact, even recently, even the co-founder, one of the co-founders of Facebook has called for the breakup of the company and the divestiture of WhatsApp and Instagram, and for new regulations to regulate Facebook and other social media platforms going forward. And some of those efforts are already underway. And I would say that they've so far been targeted at two principal topics. And we're going to look at both of them and investigate a third one that has the potential to be more comprehensive in scope. So the first one relates to data protection. And in Canada, this is largely governed by PIPEDA. And some of the issues that we currently face are related to the concept of consent. Consent is the mechanism through which individuals are given some control over their personal information, its collection and its use. But what we're seeing is that there are significant challenges for companies who are even earnestly trying to obtain meaningful consent from consumers. Consent, if an organization is going to, for AI actually has complicated these matters, creating new possibilities for the use of data, some which were not foreseen at the time of collection. Consent is primarily obtained through privacy policies in terms of service. Most of you are aware of this and interact with them regularly. But the problem is this process has become too complex and too time-consuming. There's a well-known study in 2008 that said that, and this is 11 years ago, if people at that time were to read, in order to understand, were to read all the privacy policies in terms of service that they regularly engaged with for all the different types of technologies they purchased, the social media, email, this would take 244 hours per year. There was, I believe, about 33% of privacy policies for Fortune 500 companies also required a postgraduate degree to understand. So then there's the problem of AI, which I alluded to. But the problem is that AI disrupts this framework, which is focused on point-to-point collection and use. So this used to be the traditional way that a company or a firm or even the government would collect information. If you think pre-digital world, analog world, here's my information. It's a hard copy. It's collected for particular use. And slowly things have evolved. And now through AI and driven analysis, particularly with social media, personal information can be collected in a manner that circumvents consent. Okay, so consent is vitiated, to use a term that I learned in the first year of law school. At the moment, due to at the point of collection. And I mentioned the problems with use. AI generates new potentials for data use all the time, and it's impractical for companies to come back to consumers time and time again to obtain fresh consent. Another problem is the fact that privacy policies are non-negotiable. They're contracts of adhesion. And while this is a standard practice in many industries and for other consumer products, part of the legitimacy of this approach is predicated on the availability of alternative service providers, alternative companies, alternative choices. If you're not satisfied with terms of service, privacy policy, you can shop somewhere else. Now, in the online space, a lack of competition has given consumers little to no other choice. And given the importance of email and in social media as far as communication goes, for effective or normal participation in everyday life, consumers don't really have another choice. So you could argue that this framework is is putting consumers in an illegitimate position, forcing them to choose between the protection of their rights and use of what are increasingly becoming essential services. So GDPR, this is the European data protection regulation that came into force just over a year ago. It was actually in development since, I believe, 2011, 2012. Defer to Carol on that one. And this was an attempt to address power imbalances between data collecting organizations and consumers, or data subjects. And we'll just talk about this briefly. But one of the things it did is it gave data subjects, consumers, new digital rights. Okay, so if we're thinking in the context of the human rights framework, we're thinking of the right to privacy, we're thinking of new regulatory mechanisms that were developed to make the right to privacy meaningful. Some of those were the right to withdraw consent, or data portability rights to move your data from one data processor to another. This gave consumers, or is giving consumers, more control over their personal information. And this is good. It also established new requirements for consent. So in particular cases of sensitive information, an actual affirmative act of consent is required. And the request for consent has become unbundled, must be unbundled from other contractual terms that made privacy policies very difficult to parse through. So we're already starting to hear, though, isn't GDPR already dated? And some of this is because it is increasingly challenging, as I was saying, to protect privacy by managing the process through which consent is obtained. You might call this the front end of privacy protection. The other thing is it's become difficult for companies to convey precise information about future uses. It's just too difficult. New use cases are developed frequently every other week. Sometimes they're eliminated, and you go back to the drawing board. So what about a way forward? We'll also, I think, hear this week or next week, this month in any case, about the Canada's National Digital and Data Strategy, which will include some thoughts on data protection. These might be some of them. This is my guess. New digital rights, like in GDPR, possibly to erasure of data, to have a company erase all the data that's collected from you, to withdraw consent, data portability rights, to increase consumers' and individuals' control over their personal information. But I think this is a partial solution. And there's a second line that is missing, and that is, in particular cases, the consent mechanism will need to be strengthened, possibly, as in GDPR, with an affirmative act to consent to particularly sensitive data. But in other cases, the use or the resort or the recourse to the consent mechanism may have to be diminished. Not because consent isn't important, but because it has become devoid of meaning in the context of artificial intelligence in some cases, and impractical for businesses. So one thing to do, and the Office of the Privacy Commissioner has put out guidance on this topic, and that is to articulate possibly broader scope for legitimate business purposes with more detail as far as guidelines on what those might be. And the other category is no-go zones, or cases that are clearly inappropriate or are unethical. Instead of putting the onus on individuals to manage their own privacy considerations, which is becoming too burdensome of a task, the burden will likely be shifted to companies to demonstrate compliance. I think we will see some proactive powers suggested for the Office of the Privacy Commissioner to make orders, investigate, levy fines. And then there's the issue of competition law. We don't have a lot of time to cover all the legal aspects, but thus far, competition law and assessments in the context of mergers have not really taken into account the significance of data privacy, of privacy as an aspect of consumer welfare, as an aspect of product quality. And they have not taken into consideration the potential for abuses of power that result from data aggregation, from one company amassing a data set that is so vast, or a data collecting power that brings it even more data, that yields superior insights that make it impossible for other companies to compete. Another thing, another Another potential approach, which we might see in the digital strategy, is something that Element.AI has been working on a little bit with some other stakeholders, and that is the concept of data trusts. And this would be a new form of regulation of the collection and use of personal data done through a regulated intermediary, a third-party steward, and a data trust. So we organized a workshop to study this idea, which is very much still an idea. It is being piloted in the UK and other places, but it is a maturing concept. And we put out a white paper analyzing some of the potential benefits, the shortcomings, issues to be studied, and that white paper is available on our website. I'm also happy to send it to you. I think I will go through this very quickly. So it's based on the common law concept of the trust. I'm not a trust lawyer. Maybe there are some here, so be nice. So it's based on on settling an asset, which could be data or data plus code, or even the technology that is produced from the data into a trust by a settler, which in some cases might be the data subject, or the person who is entitled to share the data, and managed by a trustee. A trust charter would contain the terms for the collection and use of the data, as well as the purpose or goal for data usage. And the trustee has a fiduciary duty to manage the assets, the data, for the benefit of a certain group or a person in accordance with the trust's terms. Some people believe that the trustee's fiduciary duty and the duty of loyalty could incentivize data sharing and use. And there's also established accountability mechanisms, including the personal liability of trustees for the proper management of the data. There are different approaches to designing data trusts. So I alluded to that. The structure of data trusts ultimately determines whether or not the data trust will serve its purposes. So and I'll go to an example, I think, to help illustrate that, which is one that people in Toronto are quite familiar with, and that is the Sidewalk Labs smart city proposal to Waterfront Toronto. And they had actually proposed a data trust, ultimately, to govern the collection and the use of the data that they would be collecting in downtown East Side Waterfront, I believe. And there was a lot of backlash about this proposal about the data trust. And besides the part of that controversy, which related to this type of project being won in a call for tender, and therefore not including participation from civil society and other groups, although those voices, I think, are being heard more now. The criticism specifically of the data trust was that it was a third-party entity, but was ultimately a subsidiary of Sidewalk Labs. So it undermined the trust that this type of structure might create in having a true third party. So after that proposal was made, some people suggested that a public institution, perhaps the Toronto, the public library, could serve as an appropriate steward. So I'll stop there, invite you to read the white paper, but the point is that the representative nature of the trustees, the structure of the trust, who gets to put the data into the trust, who appoints the trustee, who is the trustee, all of these questions must be answered and determined according to the use case for a trust to be able to live up to its expectations, which could be to increase access to data. We actually had a conversation recently with a leading physician, healthcare researcher, and policymaker who thinks the data trust could be a vehicle to increase the sharing of health data in Canada, which is very sensitive data. And currently, in the absence of mechanisms for trustworthy mechanisms for pooling data, we have fragmented data sets all over Canada. And that this type of mechanism could be one way of centralizing them and giving smaller researchers or physicians or hospitals, academics, access to a very rich data set. Okay, I'm still clicking.
I think that's telling you that your time is up.
Oh, really?
Like 3 minutes.
I got 3 minutes, okay? Algorithmic governance is the second topic, okay? We did data protection, we did algorithmic governance. There's a Treasury Board directive on automated decision-making, and what it seeks to do is incorporate principles of administrative law in proportion to their impact on the rights of people, the health and well-being, economic interests, okay? And so there are requirements to give notice before a decision using an automated decision-making system is made to increase transparency, procedural fairness, and due process. Those are implemented through access to peer review, recourses to challenge a decision, and to explain the outcome, as Richard was saying, to unpack the black box, and then introducing a higher level of accountability for higher level impact categories, requiring a human in the loop to be the ultimate decision maker. I won't talk about the US Algorithmic Accountability Act, but I understand that the slides will be available after the talk. And then the final one is leveraging the human rights framework. And so I've touched on this throughout. But some people have been doing research on, or noticed a trend that in approaching data protection, approaching algorithmic governance, we keep coming back to the protection of rights. So what if we started there? What if we measured the impact of big data and AI on the full scope of human rights and freedoms and had a more comprehensive assessment of the risk of harm? Maybe we'd be able to do what they did in the development of GDPR, which is create new digital rights to help support the right to privacy in the digital age. Okay? And so these are some of the organizations that are leading this effort. The Australian Human Rights Commission is probably the first national regulator, and at the risk of being thrown tomatoes at, I think that's true, that is coming out with a report on the impact of big data and AI on human rights and freedoms in Australia. That'll be coming out in August. And then other organizations are following suit. EU has embarked upon a similar consultation done through a call to tender, put out about a month ago. And then the European Commission, I mentioned the high-level expert group, ethics guidelines, which are grounded in human rights, and a couple other organizations, Council of Europe, Article 19, University of Essex, Human Rights, Big Data and Technology Project, Berkman Klein Center at Harvard, Data and Society in New York, Access Now, Digital Rights Organization, and of course, the Law Commission of Ontario through its Digital Rights Project in the last year, and in particular, some of the workshops they've been holding. Element.AI is hoping to build on this work, a lot of the research that has been put out and some of the recommendations as a company. We're looking at hosting a workshop in the fall on implementing the human rights approach to AI governance with recommendations for governments, practical recommendations for governments, and also for companies, AI companies in particular. And we're looking for partners, so don't hesitate to get in touch with me, and I think my time is up.